Okay. Now, I'd like to go to House Bill number 5. Item number 5, House Bill 1134, and call it up and make the usual motion.
The gentleman calls the bill up, moves the rules to be suspended. The bill considered in gross read the third time, placed on final passage. All in favor say aye. Opposed, nay. The ayes have it. The gentleman's recognized.
Thank you, Mr. Speaker. Before we get started, I do have an amendment that I'd like to add, and I'd ask the clerk to read it, please.
All right. I recognize Madam Clerk to read the amendment.
Amendment number 1 by Representative Beckett, amend on line 686 by inserting the following after the period. It is the intent of the legislature that the authority provided under this act be limited to the implementation of alternate financing arrangements that may be contemplated by any agreement entered into by the Public Service Commission and affected electric public utility relating to any qualifying facility as defined in Section 3 of the Act.
The gentleman's recognized to explain the amendment.
Thank you, Mr. Speaker. The purpose of the amendment is to clarify the intent of this legislation, and that is for us to pass this bill and one other bill that were, specifically this bill, that was contemplated in the settlement agreement entered into by the Public Service Commission and Mississippi Power Company, and that's the sole intent of this legislation, is to provide them the mechanism to complete the actions that were contemplated in that settlement agreement between the PSC and the power company.
Any questions on the amendment? I don't see any. Question occurs on amendment number 1. If you favor the amendment, indicate by saying aye. Opposed, nay. The ayes have it. The gentleman's recognized to explain the bill.
All right. Thank you, Mr. Speaker. This is a House bill. It's a lengthy bill. And I'm going to go through just a little bit of explanation about how we got to where we're at. Some of us weren't here when this started, and some of us were. But back in 2008, under the leadership of Chairman Ellis, this legislature saw fit to pass what's known as the Base Load Act. It was a lengthy discussion, but the intent of that legislation under his leadership was to provide a mechanism in order to finance, to lower the cost to the ratepayers in the Mississippi Power Company service area. And if that had been implemented, we wouldn't be here today, and we would have lower power rates ultimately on this plant. But in May of 2008, this act was passed by the legislature and signed by the governor. In 2009, Mississippi Power Company petitioned for a certificate to build a plant in Kemper, and in April of that year, the Public Service Commission hired expert consultants to consider the request of the company. Then later that year, the PSC found the need for generation, people, and this is the key component. The Public Service Commission made a determination that Mississippi Power Company would need generation by the year 2014. They had not added any baseload generation in over 30 years, and because of growth and because of other issues, the aging of their plants and changing of regulations and things, they made the determination that they need a plant. Once that determination was made, the company has to build a facility in order to protect their certificate for their customers. They're required by law to do that. And so we get to that point, they do that. Then the Public Service Commission solicited bids for the facility. The company had made a recommendation, a proposal to build this plant that they are building now, and the Public Service Commission, in an extra step of caution, said, we want to see if there are alternatives to doing this. So they sent out a proposal, and they had 18 proposals submitted. And then the Public Service Commission held hearings on this and on these bids and everything, and they selected the technology and the plant that's being built. And there was an order signed saying that you're to build a plant, we need a plant, and this is the type plant that you're to build. And then so through this process, the company is going back and forth with a PSC and submitting their request. So you get the PSC denies in April of this gets a little more complicated. About 2010, they told them they need a plant. They told them what type of plant to build. Then we got to decide how we're going to pay for the plant. And part of paying for that plant, they could have used the Base Load Act and start collecting on the front end, which would have saved hundreds of millions of dollars if that had happened, but that did not happen. They denied the company's request to do that in 2010. Then again in 2010, the company asked them to reconsider that and told them that the plant couldn't be built if they could not start collecting these costs on the front ahead of time. And that's a key point here. When they're entering into this negotiation, in order for them to secure financing, in order for this plant to go forward, they have to have this cost of work in progress, and that's the financing cost on this work in progress. And it's a key component in this. In May of 2010, the PSC issued a second certificate order granting them this recovery for 2012 through 14, and they also set the cap of how much the plant could cost. Initially, the cap was at 2.4, and in this second order, that cap was raised to 2.88. It's a cap of 2.4 that can go up to 2.88 if they show prudency of that cost. That's a determination that the Public Service Commission has to make. And that's still a determination they have to make. And I've heard people say that their cost overruns on the plant. At the current time, they spent just under $2 billion. So they're still within the range of what it's going to take to complete the plant. But in May of 2010, the PSC grants this order. In June of that year, the Mississippi Power Company accepts the conditions of the Kemper certificate and starts construction. They relied upon the action taken by the Public Service Commission to build, and that's the assurances that were made. These are written orders. These are not promises. These are not handshakes. These are orders issued by the PSC. They relied upon that in order to build the plant. And as we go forward, then the PSC has ultimately denied them the ability to collect that rate. And that's why we're where we're at today, is because of that. Now, our bill is, just a second, I got too much stuff up here. The purpose of this bill is to authorize an alternate form of financing to public utilities called securitization, which is designed to lower customer rate impacts caused by large electric generation plants through lowering financing costs. Rate reduction bonds are given high credit ratings and low interest rates and are means to minimize the financing costs of large generation plants. This bill creates in the Mississippi Public Service Commission the authority to establish a rate reduction charge. They don't have that authority currently, so without this legislation they can't do it. So we have to pass this in order for them to have this authority, which is to be used by the electric utilities as security for issuing rate reduction bonds. The rate reduction bonds are private bonds. These are not state bonds. There's no state obligation on these bonds. They're not underwritten by the state in any form or fashion. There's no recourse against the state for these bonds. These are private bonds, and they're not considered debt of the state of Mississippi. This bill does require the PSC to authorize this securitization of certain plant costs up to a maximum of $1 billion. There's not a set amount. We don't know exactly how many they're going to authorize. Right now, I think the anticipation is between $700 and $800 million. But the billion was put in simply as a cap, not an amount that's necessarily expected to be used. So the bill applies only to clean coal plants that are placed in commercial operation before 2021. Now, these costs, I want to remind you, all these costs that are going to be securitized are only the costs that are determined to be prudent by the Public Service Commission. This is not a blank check for them to circumvent the PSC and go out here and just add all their costs in here and securitize it and pass that on. Every cost added to this has to be determined to be prudent by the PSC. Mr. Speaker, I'd like to go through the bill one section at a time, just briefly, and tell you what's in each section. Section 1 just names the bill the Mississippi Public Utility Rate Mitigation Reduction Act. Section 2 establishes state policy concerning securitization. Section 3 is a definition section. Section 4 creates a new code dealing with dealing with a financing order and covering the qualified cost. It sets a limit of the $1 billion. Once issued, the financing order creates a secured property. It lays out what that secured property is and everything, and allows the utility to issue rate reduction bonds. It provides for the filing requirements applications for the petitioning utility for submitting a petition. Section 5 sets out the procedures for applying to the petition seeking a financing order and the requirements set out therein. Section 6 deals with PSC findings that must be contained in the financing order and the other requirements. Mr. Holland surrenders. It says I should surrender, Mr. Speaker.
All right. Seeing no questions, the gentleman moves final passage. Oh, excuse me. We do have an amendment, looks like. Lady from Wayne, Miss Lane.
Thank you, Mr. Speaker.
Stand between Steve and the funeral. That's what I said. Looks like we got it.
How many you got, lady? You don't know, huh? All right. Lady is recognized for her First Amendment.
Thank you, Mr. Speaker.
Recognized to explain your amendment.
Okay, the First Amendment, if you will please look at your bill beginning on line 51. This line reads, it's under financing cost, and it says on line 50, financing cost means, and then on line 51, any payment made on or before issuance of rate reduction bonds and any amount required to fund any reserves or other accounts established pursuant to the terms of any financing order, indenture, or other financing documents pertaining to rate reduction bonds. I want to amend by deleting the words "or before," so that would mean financing costs means any payment made on issuance of rate reduction bonds. We'd leave out "or before the issuance" because that makes it retroactive. Anything that they have done prior to this time would be retroactive. And that would take, on line 52, any payment made on or before issuance of rate, and then on line 52, reduction bonds, and any amount required to fund any reserves or other accounts established pursuant to the terms of any financing order, indenture, or other financing documents. We could delete any reserves or, and we would make it not retroactive by the first part of the amendment and take out fund any reserves, because I don't think my ratepayers need to be funding reserves and paying $1 billion for it. Further amend on line 62 by continuing with this amendment, amend by deleting the word reserves or, still working with reserves. And then on line 65 through 69, subparagraph 5, amend by deleting the entire paragraph. And let me read that paragraph. Financing cost means, and you've already had I, 2I, 3I, 4I, and this is 5. Financing cost any taxes, fees, franchise, transfer, profits, license, excise, severance, customs, duties, assessments, or other charges imposed by any government or taxing authority on the rate reduction bond charge, whether paid, payable, or accrued. So any tax, it looks like, on profits imposed by a government or taxing authority is considered a financing charge. Now, y'all, nobody pays our taxes. And that's the First Amendment, or lines 51, 52, 61, 62, and 65 through 69. I'll entertain any questions.
Any questions on the amendment? I don't see any. I'll recognize the chairman to respond.
Thank you, Mr. Speaker. I would ask that you oppose the lady's amendment. Part of what's anticipated in issuing these rate reduction bonds is the recovery of interest charges that are out there. That's in the agreement between the PSC. They're legally entitled to recover interest on work in progress. And if we take this out, then they won't be able to include that in the rate reduction bonds, and the customers will not receive the benefit of those cost savings. Remember that everything put in the rate reduction bond, the company does not earn a rate of return on. They earn zero off of that. It's a separate charge that goes directly to the bondholders, and there is no profit on that. So the more things that the company is willing to put in that, they're giving up their rate of return that they're legally allowed to have if they want to go through a regular rate-based case. So I would ask that you not do that, because otherwise then they would be forced to recover that under the regular rate-making process, and not only would they recover it, but they'd also earn a rate of return on those payments. So we need to encourage them to put everything they can in this, because this is saving our consumers money. The other thing, when we get down, if we delete paragraph 5, then these bonds, the company does not earn any rate of return on them. There's nothing there for them to pay the franchise fees and taxes for. If that's not included in and taken out of this fund, then they're actually going to be paying taxes on something they don't get. And so there are no profits there for them to be paying the taxes off of. And so I would ask you to oppose the lady's amendment.
I recognize the gentleman from Activity Hall for a question.
Thank you, Mr. Speaker. Gentlemen, Mr.
Yes,
Chairman,
sir, gladly.
Now, with regards to, if I'm understanding correctly, the rate mitigation and securitization of the proposal that we have before us, how would the amendment impact what we are trying to accomplish here as with regards to the credit rating that is used for, and with regards to trying to contain and you may have spoken to it, I was talking to someone else, regarding the controlling of the rates by the company, by them utilizing the securitization and mitigation process?
Basically, it'll do away with the settlement that they've reached, because this settlement anticipated this legislation that would allow them to recover this interest and put it in the rate reduction bonds instead of putting it in the rate base. If they put it in the rate base, then they earn a rate of return on it. If we allow them to put it in the rate reduction bonds, then they don't earn a rate of return on it. So it lowers the cost to the consumer if we leave it in. Her amendment would, if accepted by the company, would cost the consumer additional amount on their rate.
So you would be defeating the purpose of what?
Be defeating the purpose of this.
Okay. Thank you, gentlemen.
Recognize the author to close on her amendment.
Thank you, Mr. Speaker. I agree with the gentleman that this would enable the settlement agreement, which we didn't vote on. There were 3 duly elected public service commissioners that took this billion-dollar fee and put it on the legislature. This was up to them. If they had wanted to grant this $1 billion, they were elected to do it. Now they're going to make us go home and face 180-something thousand ratepayers, little old ladies and folks that are attending college, and your grandfathers, and we're going to go home and face them, and we, the legislature, is going to put $1 billion on them. And folks, if you don't know what $1 billion is, if you spend $1 million at $1,000 a day, you'll have spent it in 3 years. If you spend $1 billion at $1,000 a day, you will have spent it in 2,740 years. And that's what they're asking you to put on our retired people, our people that are working at the convenience stores, our loggers, and our students. Now, I would urge you to pass this amendment and let's not put all this stuff on our people. Thank you.
Question now recurs on amendment number 2. If you favor the amendment, indicate by saying aye. Opposed, nay. The noes have it. The noes have it. Next amendment.
Thank you, Mr. Speaker.
Lady is recognized to explain her amendment.
Thank you. If you will look at lines 70 through 80, of the bill, beginning on line 70, the amendment would delete lines 70 through 80, subparagraph 6, and I'll read that. Any other cost, this is talking about financing cost. Still, any other cost relating to issuing, supporting, repaying, servicing, retiring, refinancing, or refunding rate reduction bonds and all other required amounts payable in connection therewith, including, but not limited to, servicing fees and expenses, accounting and auditing fees and expenses, legal fees and expenses, consulting fees and expenses, security registration rates, trustee fees and expenses, insurance premiums, administrative fees, placement and underwriting fees, rating agency fees, stock exchange listing fees, compliance fees, duties to create or amend financing agreements, and costs to obtain waivers, consents, or approval. Further amend by deleting lines 81 through 84, subparagraph 7, which is also in part of the financing, any cost and expenses associated with the creation, operation, management, and winding up of any special purpose entity created by the electric public utility in connection with the issuance of these rate bonds. And they've got their legal fees in here, costs to obtain waivers, things that all other private companies have to finance themselves if they're a for-profit company. I really don't think that your ratepayers want you to be paying this for-profit company's legal fees, consultant fees, stock exchange rate fees. So I would urge you to support the amendment.
Recognize the chairman to respond.
Once again, I would ask you to defeat the amendment because these are special purpose rate reduction bonds. The company is not earning anything off of these bonds. Anytime you issue bonds, there are costs associated with issuing those bonds, and it does affect the overall rate. I will acknowledge that, but still the rate impact of setting this special purpose entity up and them issuing these bonds is going to be lower than the impact of including this in the rate base. It's part of the cost of doing business, and there's no way that the company can recover these costs and not make any rate of return on this investment. If they were making money off this investment, then they should pay the fees. But the bondholders, the bonds are going to be a standalone entity, and all the costs associated with those bonds need to be included in that fee.
Recognize the author to close.
Thank you, Mr. Speaker. I don't know why this has got to be a standalone entity. I don't know why we're asking our ratepayers to pay. I have no idea how many people they intend to hire for this special purpose entity created by the electric public utility just to deal with their bonds. And I don't know why we need this special thing for them. Other people don't get it. But I wouldn't mind at all if they created this entity to deal with this, if this for-profit company wanted to pay for it. But I certainly don't want to go home and face my people and tell them that they can't afford to send their kids to junior college, and they can't afford to buy coffee, some of them, But they're certainly going to have to pay everything that was in this bill, and I'll have to say this was a tight bill. It was written, no doubt, by a team of legal people that knew what they were doing. It's airtight. I'd ask you to support the amendment.
Question now occurs on amendment number 3. If you favor the amendment, indicate by saying aye. Opposed, no. The noes have it. The noes have it. Lady's recognized for her next amendment.
Thank you, Mr. Speaker. This is an amendment that would delete lines 113 through 125, which is subparagraph I of your bill. And it reads, non-bypassable. These are things that this means. This is part of your definition in here. Non-bypassable means, with respect to rate reduction bond charges, that so long as rate reduction bonds are outstanding and the related financing costs have not been recovered in full, such charges cannot be avoided by any retail consumer or customer of the electric public utility, including special contract customers, or any other person located within the electric public utilities certificated area that is directly or indirectly connected to electric facilities of the electric public utility or its successors or assigns and receiving retail electric service pursuant to a commission-approved rate. Listen to this. Y'all listen. These are non-bypassable even if such retail customer or other person elects to purchase electricity from an alternative electricity supplier following a fundamental change in regulation of electric public utilities in this state. So I'm assuming even if you put solar panels on your house at a cost of close to $100,000, if you are within, either directly or indirectly, connected to this electric facilities of this electric public utility, or anyone that buys it, you're on the hook to pay this. I would ask you to not put people on the hook even if they've got solar panels or if they have a contract contrary to this legislation. I urge you to support the amendment. Thank you.
Recognize the chairman to respond.
Thank you, Mr. Speaker. I rise to ask you to not support the lady's amendment. These bonds being non-bypassable serve a couple purposes. One, it does provide certainty to the people who are buying these bonds, and without certainty that you're going to get paid, you're going to pay a lot higher interest rate. You're going to charge a lot higher interest rate for the bond. It's that simple. People that finance understand that if you know you're going to get paid back, your rate of returns, you'll take a lower rate of return than you will if there's some uncertainty about that. The other thing is it does provide protection for companies because these bonds will be paid back. And if you start allowing some major corporation to come in and get a special deal from the company, then that burden is going to be shifted to other consumers. There aren't any individual homeowners out here going to get those individual deals, those special rate deals that are contemplated in here. But there is industry that could, and this just says that all these people are going to be treated the same. They're all going to have to pay, and the bondholders and everybody will benefit from that because they will be charged a lower rate of interest because of that certainty that the companies have. And I ask you to oppose the amendment.
We'll recognize the lady to close on her amendment.
We're hearing an awful lot about how this is going to save the consumer. I haven't had one letter from one ratepayer that asked me to support this bill because it's going to save them money. the letters I get say, I have a sleep apnea machine, and if I have to pay any more for electricity unless my church helps me again, I'm not going to be able to do it. I'd ask you to support the amendment.
Question now recurs on Amendment 4. If you favor the amendment, indicate by saying aye. Aye. Opposed, no. No. The noes have it. The noes have it. The lady is recognized for her next amendment. Lady from Sunflower, Ms. Thomas, for what purpose?
Thank you, Mr. Speaker. Introduction out of order.
You're recognized.
In the South Gallery, I would like for the House to help make welcome my sister and niece in the South Gallery.
Lady is recognized to explain her amendment.
Thank you, Mr. Speaker. This amendment begins on lines 235 through 236. If you'll look at your bill, beginning on line, this is in section 5, beginning on line 232, I'm going to read so it'll make sense, and then I'll get to the amendment. Proceedings on a petition submitted pursuant to section 77-3113 shall be disposed of in accordance with the provisions of section 77-347 and applicable commission procedural rules. Okay, that's on the Public Service Commission where it belongs, but read the rest of the sentence. Except that the provisions of this section, 773-115, to the extent applicable, shall control. So the legislature, by using that sentence, is taking proceedings on a petition submitted pursuant to other code sections and telling the commission that this section that we're passing controls, instead of putting it on the Public Service Commission, who are elected from all over this state. So that's the first part of the amendment. Further amend on line 3, well, that's part of it, the extent applicable shall control. So we're deleting except that the provisions of this section 77-3-115 to the extent applicable shall control. That's all we're deleting. We're keeping the Public Service Commission in it. I urge you to support the amendment.
Recognize the chairman to respond.
Thank you, Mr. Speaker. I again rise to oppose the lady's amendment. The procedural matters set out in 77-3-115 are those contemplated by the Public Service Commission and the company when they sign their settlement order. There are timelines in there that are very important, and this complies with the timelines that they've agreed to. So we're not circumventing the PSC. They agreed to this procedure for these shortened timelines of filing this information. As you oppose the amendment.
Recognize the author to close.
I don't know how many people had input into this agreement between the PSC and the Mississippi Power Company or Southern Company. I don't know who had input into it, but this was an agreement made with Public Service Commissioners without being voted on by taxpayers, without any of us having any input whatsoever, without notice to ratepayers of exactly what was going on, because they trusted the Public Service Commission to take care of them. I suggest that if the Public Service Commission wants to take care of them, we should let them do it and not put it on this legislature, on this bad bill, to take the blame for raising these rates. And if the Public Service Commission wants to do it, they certainly have the power to do it. I'd urge you to support the amendment.
Question now recurs on amendment number 5. If you favor the amendment, indicate by saying aye. Aye. Opposed, nay. No. The noes have it. The noes have it. Gentleman from Jackson, Mr. Reed. I understand needs to have a rules meeting. Gentlemen, have a time-sensitive matter regarding a funeral or something for tomorrow. So the gentleman from Jackson calls a rules meeting in the rules room. Lady is recognized for her next amendment.
Thank you, Mr. Speaker. This is to amend by deleting lines 262, everything after the semicolon, and further amend by deleting lines 263 through 283, and this is what you would be doing. On line 261, it reads, any judicial review shall be provided as in section 77-3-72. The amendment would delete that semicolon and put a period. And then this is the rest of the language you would be deleting. Providing, however, that any person other than the electric public utility that is the subject of the financing order seeking to appeal a financing order issued pursuant to this article or any prudent determination related thereto shall not perfect its appeal, and y'all better listen to this. This is your right to go to court. Shall not perfect its appeal unless and until a bond of sufficient amount to protect these customer savings projected to be realized through the issuance of rate reduction bonds as determined by the Commission in the financing order pursuant to section 77-3-117B is filed with the Commission prior to expiration of time provided under section 77372 for notice of appeal. What this is doing is saying that all these wonderful millions and billions of dollars of saving that we're supposed to get by paying for this as we go and by going above the $2.8 billion that the Public Service Commission's got you on the hook for, you can't even appeal this order. Now notice, it doesn't apply to the electric utility, but it applies to the others without posting a bond of sufficient amount to protect the consumer savings. Now they're saying we're going to save millions and millions, projected to be realized through the issuance of rate reductions bonds as determined by the Commission in the financing order. So this is keeping you from going to court unless you have the money to post millions of dollars in bonds. And go on down to lines 279 and 283, all that in between is included. A financing order shall provide that any and all deferred return of the electric public utility during the pendency of an appeal may be financed as qualifying costs pursuant to the provisions of this article. So not only are you going to have to put up a bond undetermined right now, but could be millions or even billions, but they are going to count as a finance cost all deferred profit. All deferred profit. And I just don't really feel like that's fair to the ratepayers.
There's a lady here for a question. Gentleman from Hines, Mr. Brown.
Thank you, Mr. Speaker. Lady Yield.
Yes.
Now, I want to be sure I understand all this. In this, as you know, I'm not an attorney, but tell me exactly what this provision says. So would you say that instead of reading it, tell me just sort of in layman's terms what this means?
As I read it, it means that the electric utility does not have any thing in here about what kind of bond they have to post, but any person other than the electric public utility that's subject to the financing order that wants to appeal a financing order has got to put up a bond, and it's undetermined, gentlemen, as to the amount of the bond, because it says a sufficient amount to protect the consumer savings projected to be realized through the issuance of the bond rate reduction bonds.
So it's a bond of an undetermined amount. The Commission would determine how much profit or how much savings is being foregone but there's no time period for that savings, that calculation. In other words, it could be till the end of the bond, could be billions of dollars worth of bonds.
Until the appeal is completed, and assuming it takes a while to complete the appeal, which it probably would in a case like this, the electric utility has further protected itself by...
Lady's time's expired on her amendment. She'll be allowed to close. Recognize the chairman to respond.
Thank you. I want to make one thing clear. There's not a profit on these bonds. Occasionally there's been a reference to a profit on the bonds. There are interest charges on these bonds that the bondholders are going to get paid, but it's not a profit on the bonds. The other thing is, once again, dealing with certainty. If one individual, if you do not do this, then anyone can. The customers are going to lose this rate reduction. If you just want to keep it tied up forever and ever and ever, and individuals can, then all these 180-something thousand people we're concerned about are not going to experience this savings. And at the end of the day, when it's settled, then this interest will be paid, and we could be paying interest on interest. And this language is primarily in here once again for certainty as it relates to the people buying the bonds, knowing they're going to get paid and going to start getting paid immediately. And I'll yield to the gentleman's question if he's wanting to ask me one. Or
Gentleman from Hines, Mr. Brown.
Thank you, Mr. Speaker. Following up on the question I had to the lady now, I'm for you, Bill.
To me or
no,
her?
this is to you, but
Okay.
Following up on that same line of questioning, I do have some concern here. Basically, you're saying that as a practical matter, nobody can ask for a judicial review because nobody can afford this bond. I mean, there's no way to know. It's an undetermined amount, and as a practical matter, even if they've got a legitimate concern or a legitimate issue that ought to be considered in judicial review, they can't do that because they can't post a bond. Nobody can get the bond. I mean, we don't know how much is. If you had a bond of a reasonable amount, I think it might be something that should be considered, but this is an undetermined amount. There's just no way to know. It could be billions of dollars.
It is a bond that will be determined by the PSC.
I understand that, but the way the language is drafted, it says all foregone savings, and you're talking about savings of how much, do you think?
Eventually $1 billion over 40 years.
Okay, so we're talking about $1 billion bond. Now, you can't even get $1 billion bond. So
well, I don't think the PSC would require $1 billion bond because there's nothing going to last 40 years. But there should be some. I think that I trust them to have a reasonable bond if someone wants to appeal this. But there isn't a limit, and I will acknowledge to you.
I'm sorry.
I will acknowledge your point that there is not a limit.
There is not a limit on the amount of bond that should be posted. Are there other? And again, I'm not a lawyer, it's an open-ended question. I don't know the answer to this. Are there other proceedings in which you post a bond of an undetermined amount, where the law says just whatever it is you post? And I know they're double and triple and all that kind of stuff. Can you give me some examples where this type of language is used in the law?
I can't give you that example. I'm not aware myself of that example. I'd be misleading you if I told you I knew whether it was or was not.
Okay.
I have no knowledge of that.
I just think that this is not only, it just seems to me what you've done is effectively barred anybody from asking for a judicial review here. Is that the right thing to do, the wrong thing to do? I think it's the wrong thing to do. The rest of the bill seems to me to be something we ought to consider, but I would just ask you to look at that as we go forward.
Right.
That just seems to be a little bit over the top.
Well, I can tell you with the amendment we've adopted, our bill is different from the Senate bill, and I'm sure we can look at that as we go forward.
Thank you.
I ask you to oppose the
As
amendment.
the author to close on her amendment.
Thank you, Your Honor. We have all seen conference reports that came back without anything that we realized that we'd voted on in them, and it could happen here. But I would ask you, let's don't trust this to chance and conference and what the Senate side may say. I would ask you to take this out so that if someone has a legitimate, lawful appeal, they are not prevented, they are not given due process of law in their day in court, because this legislature has authorized an undetermined amount that might go up to $1 billion, and you can't get that. You are taking away the key to the courthouse. Thank you.
Question now occurs on amendment number 6. If you favor the amendment, indicate by saying aye. Opposed, no. The noes have it. Noes have it. The lady's recognized for her next amendment.
As I offer these amendments, I want to apologize to this body for doing this on a Friday morning and for coming up here as often as I do. I know it gets tiresome, but having read the bill and seen things that I feel like need to be addressed in the course of having done this for 22 years for people, I feel I'd be derelict if I don't do it. On line 321, on line 321, it says that, however, the Commission shall afford the issuing entity flexibility in establishing the terms and conditions for the rate reduction bonds to accommodate changes in market conditions, including but not limited to repayment schedules, interest rates, financing costs, collateral requirements, required debt service and other reserves, and the ability of the issuing entity at its option to effect a series of issuances of rate reduction bonds and correlated assignments, sales, pledges, or other transfers of security property. The amendment would replace the word shall with may. We would not, as a body, be ordering an elected commission that they shall afford. We would be giving the commission they may afford. We wouldn't be ordering the commission what to do. And then amend further on lines 334 by replacing the comma after market conditions with a period. That would make it read, the Commission may afford the issuing entity flexibility in establishing the terms and conditions for the rate reduction bonds to accommodate changes in market conditions. It would end with a period. It would not include this language, including but not limited to repayment schedules, interest rates, financing costs, collateral requirements, required debt service, and other reserves, and the ability of the issuing entity at its option to effect a series of issuance of rate reduction bonds and correlated assignments, sales, pledges, or other transfers of secured property. We will have given the Commission the ability, may, and not ordered them to, and they know what all this is. We don't have to give them specific language on how to do their jobs. They're elected just like we are. Thank you.
You yield for a question, lady. Recognize the gentleman.
I will.
Activity Hall, Mr. Ellis.
Thank you, Mr. Speaker. Gentlelady, on that language that you just alluded to, would that not circumvent what's already law in the part of the promulgation of rules and regulations that the Public Service Commission was instructed to do in the original bill several years ago? I mean, that they were charged with that responsibility on the prudent audits and the whole establishment of the promulgation of the rules and regulations, were they not, in the original bill?
If it's already in law, I don't know why we have to have it. We're not deleting the law in this bill. We're not deleting the law.
But I'm asking, are you changing what's already in law?
I don't think so. I just think we're not ordering the Commission a laundry list of things that they should do.
Okay. Well, I beg to differ. I think they're already instructed. That was part of the original bill, is that they had specific instructions. And I also think that the preamble that the gentleman originally amended the bill to instructs them to be prudent as well. But I stand to be corrected, but I believe that is the case. Thank you.
Recognize.
Mr. Speaker, in that case, I would like to amend the amendment or to offer a substitute amendment.
Okay, do you have it prepared, lady?
Just mark out everything after the word may on the amendment. And all we'd be doing would be amending on line 321 by deleting the word shall to the Public Service Commission and replacing with the word may, and the rest of the language would remain the same.
Well, I think you need unanimous consent to change what you have already. You need to provide a substitute amendment, or you need unanimous consent to change this amendment, I believe. I think that's proper procedure.
Somebody hand me a blue form.
Does anyone object to changing the amendment as she has filed it? I hear none. So
we're down to changing the word shall to may as to the Public Service Commission. Thank you.
all right. I recognize the chairman to respond.
Mr. Speaker, I ask you to oppose the amendment because if the Public Service Commission had done what they may do, we wouldn't be here today, and so that's why shall's in there. We need to know that they're going to follow through with what's in this act, and I ask that you defeat the lady's amendment.
Recognize the author to close.
The gentleman makes my point. He said if the Public Service Commission had done what they should have done, we wouldn't be here today. They've already authorized $2.4 billion plus cost of the mining and the pipeline. That's put it up to $2.8 billion. Maybe they think that's enough for a private company. And I would like, instead of them putting it all on us, by us ordering them to shall, that we give some of this back to the commission and allow them to do, as the gentleman said, what was in the original bill and what they're supposed to do. I urge you to support the amendment.
Question now recurs on Amendment 7, Part 1. If you favor the amendment, indicate by saying aye.
Aye.
Opposed, no. The noes have it. The noes have it. Ladies recognized for her next amendment.
This amendment begins on line 354 of your bill. This says the electric public utility retains sole discretion to establish a special purpose entity and cause it to issue rate reduction bonds. An issuing entity established by an electric public utility pursuant to this article shall not constitute a public utility pursuant to Section 77-3-3. Again, I don't know on this part of the amendment why we need a special purpose entity. We already have people in place that we pay to do bonds. And the remainder of that deletes all of Section 3 and all of Section 4. And you might be interested in this. In Section 3, let me go to Section 4. In Section 4, a financing order shall remain in full effect and unabated, notwithstanding the reorganization, bankruptcy, or other insolvency proceedings of the electric public utility or its successors or assigned, subject to the issuance of rate reduction bonds authorized by a financing order. The financing order shall be irrevocable, and the Commission may not amend, modify, or terminate the financing order by subsequent action. The Commission may not reduce, impair, postpone, terminate, or otherwise adjust the rate reduction bond. So again, this is irrevocable, and we're taking everything away from the Commission and putting it on this legislature.
Recognize the chairman to respond.
Thank you, Mr. Speaker. A couple of things. One, by creating this special purpose entity, you are actually segregating this money over here, and to be clear that the company is not earning anything off the money. They're not handling the money. and it will provide protection to ensure that it's not commingled with their other funds. They can't use it for anything else. It strictly goes to pay back these bonds. And the purpose for not allowing any changes, when you finance your home, you can't go in and unilaterally just change your payments. I mean, we are borrowing money from individuals, and as part of the process of doing that, we're guaranteeing them that we're going to pay this money back, and that we're not going to change the terms on them. I ask you to oppose the amendment.
Recognize the author to close.
You've heard the amendment up to the will of the House.
Question now recurs on amendment number 8. In favor of the amendment indicate by saying aye. Opposed, nay. The noes have it. The noes have it. Next amendment.
This is in section 7, subparagraph 2. Amend by deleting beginning at the word limited on line 410 through the period after the word mechanical on line 412. Beginning on line 409, the Commission's review of the true-up report. We haven't discussed the true-up report, but it's a procedure that is in this bill. The Commission's review of the true-up report shall be limited to a determination of the existence and amount of any mathematical errors in the report concerning the application of the approved true-up adjustment mechanism. Now, folks, when you start limiting the Commission that's reading a report, the true-up report, which is the accountability report, I suppose, when it is limited to a determination of the existence and amount of mathematical errors, that is truly no oversight, and I do not know how you explain that to people at home, that we have authorized. The only oversight the Commission would have on the true-up report would be mathematical errors, and that is.
Recognize the chairman to respond.
I'm sorry, Mr. Speaker. Further amend by replacing on line 410 the word limited with the words unlimited. We would have deleted everything through 412, and the Commission would have unlimited power on this true-up report. Thank you.
Recognize the chairman to respond.
Thank you, Mr. Speaker. The purpose of the true-up report, it is a mathematical equation. It's to determine that the amount of rate is what is necessary to generate the amount of money that's required. You set kind of a little bit like millage. You come up with a dollar amount, then that's determined how many mills you have to put on to generate that money. So if they put a 2% rate on and it generates too much money, then you mathematically you would adjust that back down so that it would collect the right amount of money. And conversely, if they weren't collecting enough, you would do that. And that's the purpose of the report, to ensure they're not collecting more money than they need or less money than they need. So it is a mathematical deal, and I ask that you defeat the amendment.
Recognize the author to close.
You've heard both sides. Vote your conscience.
Question now recurs on amendment 9. In favor of the amendment indicate by saying aye. Opposed, nay. Noes have it. Noes have it. How many more you got, lady?
One more.
One more. All right. Lady is recognized for her last amendment. Gentleman from Grenada, Mr. Horan, do you have an amendment? Any other amendments out there? I don't see any. Ladies recognized.
Thank you, Mr. Speaker. The ones of you that are thinking about buying some of these bonds are going to be very interested in this amendment. Beginning at Section 8, line 431, The following shall be codified as certain section of the code, 77-3-121. The rate reduction bond is a non-bypassable charge, and in the event an electric public utility subject to a financing order as a result of insolvency, sale, a fundamental change in regulation of electric public utilities in this state, or any other reason ceases to serve customers within all or a portion of its certificated area, the Commission shall have the obligation to ensure that the rate reduction bond charge is collected and transmitted to the issuing entity by the subsequent utilities providing service in such certificated area or portion thereof, no longer being served by the electric public utility that originally petitioned for the financing order. Now, the ones of you that want to buy these bonds, listen to Section 2, subsection 2 of 8. If an electric public utility fails to remit any required payment of rate reduction bond charge revenues to the assignee, issuing entity, financing party, or bondholder, as applicable, such assignee, issuing entity, financing party, or bondholder shall have no legal remedy, either at law or equity, against the electric public utility or its assets, except specifically provided below. So you have got no legal remedy under this at law or in equity. That's Chancery or Circuit.
Recognize the author to respond. The chairman to respond.
Thank you, Mr. Speaker. I do oppose the amendment. If we were to remove this section, then we would remove the ability of the PSC to authorize these rate reduction bonds, and which are contemplated in the settlement. They have no authority to do this unless we pass this legislation and allow it. And so I oppose the amendment. Thank you.
Recognize the author to close.
The amendment is just trying to protect the rights of the assignees or the bondholders. I urge you to support it.
Question now recurs on amendment number 10. If you favor the amendment, indicate by saying aye. Opposed, nay. Noes have it. Noes have it. Recognize the gentleman from Grenada, Mr. Horan, for an amendment.
Thank you, Mr. Speaker. I'll refrain from calling you Your Honor today, if that's okay.
That's okay. You can call me that anytime, John.
My amendment basically does one thing, limits the amount of attorney's fees that can be paid on this particular, and it's something near and dear to my heart, as y'all all know, but limits the amount of attorney's fees to $500,000, and it requires that the RFP's process will be used by the Commission. Either the Commission shall utilize it or have it utilized, basically, through the process of hiring bond counsel. I think this is something, if you look at what 1% of this would be $10 million, folks. $500,000, I think, sufficient for counsel. And anything in excess of that, $9.5 million or whatever that would be, some arguing about whether or not that would be 1/2 of 1% or whatever, regardless of it. $500,000 attorney's fees is sufficient. And, Mr. Speaker, I want to say while I'm here, I got to get out of here. I think this bill is fundamentally unfair to every member of this chamber. I don't think when we elect commissioners to do a job, take care of ratepayers, this should be put on our backs. This is unfair. And I don't care if you're a Democrat, Republican, Tea Party. If I have a family member in your district and you have a mail out that comes out against you on this vote, you call me, I will come running for you to defend your vote either way on this particular bill. This is a shame that when I get calls all day long about water meters, things of that nature, or testing water, I call the Public Service Commissioner and I get a response. But on this bill, I can't get them to give me an answer on where I should be on this. You know, we all have responsibilities when we become elected officials, and you need to do your job. This is not our job to be messing with this piece of legislation. I encourage you to support my amendment. It's short and brief. This is a sad day, really. Thank you. I urge you to support the amendment.
Gentleman yields the podium. Recognize the chairman to respond.
I sympathize with the gentleman about his sentiments, but I do rise to oppose his amendment. I told him that if this were public money, any money we put out here for that we're spending our taxpayer dollars on, I'll be glad to support his amendment if he does it. These are bonds going to be issued by a private company, and I just don't feel like that we need to be involved in that process. So I ask you to oppose the amendment.
I recognize the author to close.
Thank you, Mr. Speaker. I don't know if you call it private or public, but I think when you're asking these ratepayers to increase their rates on a vote like this, I think that at least the commission ought to have some say. They hopefully won't take the gas on this particular part of this legislation, at least monitor at least this part of it, and do something to keep their hands on this particular piece of legislation. I urge you to vote for this particular amendment. Thank you, Mr. Speaker.
The gentleman yield. Does the gentleman wait for a question?
I do.
The gentleman from Washington, Mr. Hine.
Gentlemen, am I understanding you correctly? You're a lawyer and you want to cap lawyers' fees?
I didn't say cap it. I just said it wouldn't be in excess of 500. That's not a cap.
I think that's a good amendment when you see lawyers trying to hold other lawyers down.
I'm not trying to hold them.
Gentleman from Hines.
They
Mr.
don't
Brown.
have to take the business.
Thank you, Mr. Speaker. Gentleman yield.
Certainly.
Now, the chairman of the committee said this is a private company, and if it were being paid for by the taxpayers, he might support it, as I understood him. Won't this go into the bond? This would be deducted from the bond proceeds,
Correct.
and therefore will be paid for by the ratepayers.
Correct.
Is that not correct?
That is correct.
If it's $1 million or $10 million in legal fees, that's coming out of ratepayers' pockets.
Correct.
So you are actually going to lower the amount of money the ratepayers would have to pay in legal fees. Is that not correct?
That is correct.
Thank you, gentlemen.
All right, the question now recurs on amendment number 11. If you favor the amendment, indicate by saying aye. Aye. Opposed, no. No. The ayes have it. The ayes have it. Okay, Chairman of the Public Utilities.
Thank you, Mr. Speaker. It's been a lengthy process, and I think everybody knows what they're going to do. I just encourage you, as difficult as it may be for you, to know that we are sent down here to make difficult decisions from time to time.
Excuse me, Mr. Chairman. The lady from Wayne has asked to speak on the bill, so I will recognize her first, and then I will recognize you.
Thank you, Mr. Chairman. You got a paper on your desk. I know we don't look at a lot of them. This one came out yesterday, showing a graph of the difference between $1 billion and $1 million. And the millions down here in this little thing, and this is 1, 2, 3, 4, 5 times 2 of bills. I'd ask you to think about that. And think about this. The CIO of Southern Company made $9.7 million in compensation last year for the 2010-2011. That was an increase of $3.7 million from the year before. Alabama Power CEO made $5.3 million. That was an increase of $858,000. The Chief Financial Officer, Executive Vice President, made $4 million in 2010-11, an increase of $1.9 million. Mississippi Power Executive made $4.8 million, an increase of $1.6 million. Mississippi Power's operating revenues last year were $1.11 billion. They had profits of $94 million. And they've already been granted, with our pay-it-forward method, $2.88 billion from the Public Service Commission. And they still want more. I don't know when it stops. But if they happen to get out of this, and we can't afford to post bond to have legal things, we're going to have a WorldCom situation if people hold these things. One lady wrote me, as a 52-year-old woman who is disabled and on a very fixed income, I'm asking you to vote against this bill. I'm unable to pay my electric bill now and have had to hold garage sales to raise money to pay this bill. I don't have cable, a computer, internet, a home phone, or any other gadget most people consider necessities. I keep everything unplugged that I can now at home. I use a small fan and a lamp to read by. If I'm not able to pay my bill now, how will I be able to pay it if this passes? In the past, I did ask a church to help me. They gave me $35, which helped me defray the cost of the bill. I understand that now the funds have dried up at the different charities, and some of my friends are without electricity because they can't pay the bill. I've had this happen to me several times, and I hope I do not have to go through this devastating time again. Please vote against this bill that can only do harm and no good for the citizens of Mississippi. And one other lady wrote that this is just another case of corporate welfare. Privatize the profit and socialize the risk. I ask you not to support this bill.
Gentleman from Lincoln, Mr. Moat. Passes. Recognize the chairman to close.
Thank you, Mr. Speaker. As I was saying, it's been a long day, and I think people know what they're going to do. And I would like to use the same statistics that the lady just used, and that's exactly why I'm here. $1 billion is a lot of money. And a vote yes on this bill saves the ratepayers of Mississippi Power Company $1 billion over the life of this plant. You have a choice. You may not want to be here. And I know a representative, she gave some statistics on what people make. And we make $10,000 plus expenses to be here, but this is our decision to make. And it's difficult to make, and I know we don't want to, but just want to remind you that a vote yes saves the ratepayers $1 billion. They were authorized to build this plant, and they're entitled to recovery, and this is an attempt to recover it in the cheapest method possible for the consumers. And I ask that you pass this bill.
You yield for a question, gentleman.
I will yield.
Gentleman from October Hall, Mr. Ellis.
Thank you, Mr. Speaker. Mr. Chairman, now, a lot has been said about voting against this bill to save the ratepayers money. Now, let's be clear. Is it your representation that if you vote for this bill, it will limit the amount of increase to 25%? Is that correct?
That is correct. It will limit the increase that the ratepayers will see.
Now, with a vote no against this bill, what would the ratepayers be?
Approximately 6% higher than that.
Which is
what we're doing to anticipate. Depends on exactly how much gets securitized, but around 6% increase is what we're saving.
So then, conceively,
it could be over 30%.
Over 30%, anywhere between 30 and 35% increase.
Correct.
So it's not a question of 0%. It's a question of 25% or 34, 35%.
Exactly.
So voting for this bill will conceivably save the ratepayers, and also the sticker shock that they will have if they have to wait until the plant comes online, which is 2014.
Exactly.
And they will all just come down at once according to the baseload generation that
Exactly.
we passed. Okay. Thank you.
All right, gentleman moves final passage. Open the machine, Madam Clerk. Question now recurs on House Bill 1134. If you favor the bill, vote aye. If you're opposed, vote nay. Has everyone voted? Has everyone voted? Has everyone voted? Close the machine, Madam Clerk. By a vote of 90 yeas, 26 nays, bill passes.